How does arbitration resolve business disputes? Imagine two companies having a disagreement over a contract. Instead of going to court, they choose a different route to settle their issue. That route is arbitration. Arbitration is a way for businesses to solve conflicts privately, outside of the traditional court system. It involves a neutral third person or group called arbitrators who listen to both sides, review evidence, and make a final decision. This process is often faster and less costly than going through a court trial. The process begins with an arbitration agreement. This is a written contract where both companies agree to settle disputes through arbitration instead of court. It clearly states how many arbitrators will decide the case, where the hearings will happen, and what rules to follow. Sometimes, the agreement specifies which arbitration organization to use, like the American Arbitration Association or the International Chamber of Commerce. Other times, it is an ad hoc arbitration, meaning the parties handle it on their own without an organization. Once the agreement is signed, if a dispute arises, one company submits a demand for arbitration. This includes details about the disagreement and any required documents. Sometimes, before formal arbitration begins, the companies try to resolve the issue through informal talks or mediation. If that does not work, the arbitration process moves forward. Choosing the arbitrator or panel is a key step. If the companies cannot agree on who should decide, the arbitration organization provides a list of qualified candidates. These experts have knowledge in areas like business law, trade, or industry-specific issues. The companies review the list and select their arbitrator, either by mutual agreement or randomly. This helps ensure the decision-maker understands the business context. Next, the parties agree on how the hearing will be conducted. They decide what evidence can be presented, how witnesses will testify, and how long the process will take. Unlike a court trial, arbitration hearings are usually less formal and happen in private locations. Both sides present their cases, call witnesses, and submit documents. The arbitrator listens carefully to everything before making a decision. After hearing all the evidence, the arbitrator issues a final and legally binding decision called an award. This award is enforceable by law, and the parties are required to follow it. Unlike court judgments, arbitration awards are rarely appealed, providing a clear resolution. If one party refuses to comply, the other can ask a court to enforce the award. Businesses often prefer arbitration because it saves time and money. It keeps disputes out of public view, protecting company confidentiality. The ability to choose arbitrators with specific expertise means complex issues are decided by knowledgeable people. The finality of arbitration helps companies move forward without lingering uncertainty. Today, many business contracts include clauses that requiring disputes to be settled through arbitration. Courts generally enforce these clauses, making arbitration a trusted method for resolving conflicts. It offers a balanced mix of privacy, speed, and certainty, making it a popular choice for resolving business disagreements efficiently.